Welcome back to the Michigan Business Beat, brought to you on the Michigan Business Network. Chris Holman from Studio B. Let's just leave it at that, okay? We're in transit today, but we are going to stick around the mid-Michigan area. Well, actually, we're going to go way beyond that because this particular law firm that we're having on is all over the state. We're spending some time with Anthony Dalimonte. He's an attorney with Foster, Swift, Collins, and Smith. In Southfield and half a dozen sites around the state of Michigan. Anthony, it's good to have you on. How are you doing?
I'm good, Chris. Thanks for having me.
So we're going to talk a little bit about name, image, and likeness. And no, this is not family tree stuff. This basically talks about athletics. Bring us up to date.
Yeah, absolutely. So, name, image, and likeness, often abbreviated as NIL, refers to the rights of individuals, and it's in the mainstream media, referring to particularly college athletes, to have control and to monetize their own personal brand. And this encompasses their name, voice, photograph, other identifiable attributes that can be associated with their, public persona. And so how did we get here? I think most people know that historically it was an NCAA violation for a college athlete to make money off of their name, image, and likeness, or to, sign an endorsement deal while they were in college. And I'm sure your listeners have, seen all the things in the news over the last couple of years. But in 2021, the U.S. Supreme Court in the NCAA v. Alston case found that it was a violation of antitrust law to restrict college athletes from profiting off of their name, image, and likeness. So as a result, the NCAA changed its rules and implemented a new interim policy that allowed college athletes to engage in these NIL activities, so long as they're consistent with the law of the state where the school is located. And to date, 32 states, including Michigan, have passed NIL laws that are largely modeled off of California's Fair Pay to Play Act.
So let's dive a little bit into the details of this Michigan's NIL law. Can you provide us kind of an overview?
Yeah, sure. So Michigan's House Bill 5217 is Michigan's NIL law, and that went into effect on December 31st, 2022. And that provides basically that colleges and universities are prohibited from doing the following. They can't prevent a student athlete from competing in college athletics because they earn compensation from an NIL deal. They can't prevent a student athlete from obtaining professional representation, such as an agent or an attorney. Schools can't pay a student athlete compensation directly for the use of their NIL rights. And schools can't revoke or reduce a student athlete's scholarship because they enter into an NIL deal. So that's the school's responsibilities. On the student athlete side, they also have obligations and they must comply with state laws. And specifically in Michigan's law, student athletes, if they can't advertise for a sponsor that creates a conflict with the sponsor of the college. So if the University of Michigan is a Jordan brand or Nike, then a student athlete can't go to Jordan or Nike and sign a sponsorship deal there. Athletes are required to disclose the NIL opportunities or contract that they hope to enter into at least 7 days before entering into that contract. They aren't granted any right or use to the intellectual property, logos, or copyright of the university. And basically, they're required to follow the university's academic requirements, team rules, and disciplinary standards as well. So that's Michigan's law. We also have the NCAA regulations you have to comply with. And each schools are starting to develop their own NIL policies that may or may not be more restrictive. So there's a lot of patchwork of regulations out there right now.
Well, there certainly is. We've got a lot of business people, obviously, that listen and watch these shows. What advice would you have for them in how to contend with this and maybe this new landscape, and of course, establish partnerships with student athletes?
Yeah, I think the new rules provide a fantastic opportunity for businesses, looking to explore new ways of marketing their products, especially in areas where there's strong support for a particular school or athlete or sport. So, from a legal perspective, I think it's, important for businesses to make sure you have a well-drafted contract that, outlines the obligations of both parties and, protects both the business and the student athletes, because there is an added element of compliance here. You have to comply with the school's policy, the NCAA policy, as well as the state law. So, I think those are the main things.
Anthony, we got about 30 seconds left. What's the meaning of life? No, just to wrap it up, tell me a little bit about what you see in the future with this NIL.
Well, I think if we've seen anything in the last 2 years, it's that this landscape is going to constantly change and rapidly. I'll leave you with one interesting development before we're done. There's a case right now in the Third Circuit that's basically deciding whether or not the NCAA is a joint employer, which could mean that student athletes could be considered employees of the NCAA, and that would change everything. So that ruling will come down in the fall, and it'll be interesting to see how it shakes out.
Well, Anthony, don't move because I know we're going to be back to you on this. All right.
Sounds good.
Anthony Dalimonte, attorney with Foster, Swift, Collins, and Smith, all over the state of Michigan, as a matter of fact. We're going to be right back. You're watching the Michigan Business Beat on the Michigan Business Network. I'm Chris Holman.